Hello again, I'm Will Hughes, and today I want to cover episode 4 in the basic introduction to construction contract law. We're going to look at contract types. So we're going to focus today on the kinds of contracts that you might encounter when you're looking at construction. The questions that we will be dealing with in this video are: what are the types of contract, such as simple contracts and deeds, and what form might a contract be taken? We'll look at verbal contracts, written contracts, bespoke contracts, standard form contracts, and amended standard form contracts. Okay, so the first thing is verbal contracts, because it's important to note that a contract does not have to be in writing. Quite often we identify contracts as being written documents, but it's not absolutely necessary. In the previous episode, we defined a contract as an agreement, and therefore it is not necessarily a document. It is necessarily an agreement, and the agreement is evidenced by the offer and the acceptance. So it's not necessary for the agreement to be recorded in writing in order for English law to recognise it as a contract. Of course, contracts for construction involve huge quantities of resources and multiple people carrying out work in lots of different places over a sustained period of time. The amount of documentation required for a construction project simply to record what has been agreed is prodigious. But even so, the actual agreement is sometimes not written down, even though there's a lot of documentation. Of course, you can imagine that this might lead to problems later on in the process. So let's look at types of contract, whether written or verbal. First, there's a type called a simple contract. This can be split into two types, as a bilateral agreement or a unilateral agreement. So a bilateral agreement is when one party promises to do something in return for somebody else doing something for them. For example, paying somebody to do some work. In this situation, a bilateral contract, both parties take on obligations. On the other hand, there are unilateral agreements, a binding promise by one person to do something for another person as a result of some kind of event. For example, offering a reward to somebody for finding your lost dog. In this kind of agreement, only one party assumes an obligation. And remember, since there's no requirement in law for a contract to be in writing, you have to be very careful about what you're promising. Simple contracts are also known as contracts that are signed underhand. That kind of implies that they're written, but we'll see later why we call them signed underhand. And of course, this kind of agreement is an enforceable agreement, one that you can take legal action on. So in simple contracts, actions for breach of contract can only be commenced within 6 years of the date that the cause of action arose. Now, that's not the same as the date the contract was signed, nor is it the same date as the date that the work was done. But if damage occurs because of work under a simple contract, then the clock starts to run at the date the damage occurred, or the date that the breach occurred. And the clock runs for 6 years. This is by virtue of a statute in English law called the Limitation Act 1980, and this arises under Section 5 of that Act. So if there's a breach of contract under a simple contract, you can start to take action within 6 years of the breach occurring. If 6 years have elapsed, then you are barred from taking any action. The other main contract is known as a deed. This is also known as a specialty contract by lawyers, but please note this is not speciality, specialty. A deed differs from a simple contract in many different ways. A deed is a specific type of binding promise, even if it is a promise that is conditional upon something being done by somebody else. Lawyers describe this as a serious agreement to be bound to do something. And a deed does not necessarily require bilateral obligations. It may be a unilateral contract, and it sometimes is. A deed must be signed by both parties in order for it to be valid. This is because of Section 2 of the Law of Property brackets, Miscellaneous Provisions, close brackets, Act 1989. That Act makes it necessary for a deed to be signed, to be executed in writing. So in that sense, a deed differs markedly from a simple contract. Another difference between a deed and a simple contract is that actions for breach of a deed can be commenced up to 12 years after the date of the cause of action, rather than 6. And this is because of Section 8 of the Limitation Act 1980. So it's quite common for clients of construction projects to prefer to use deeds rather than simple contracts, simply because it gives them a much longer period of protection, as they see it, in terms of being able to take action for breach of contract. These days, in English law, if you want your contract to be a deed, you simply have to state in writing that the contract is executed as a deed. Historically, of course, it was done under seal. So you might have seen on the movies somebody dropping red sealing wax onto a document and then impressing their signet ring into that molten wax. That is what was called a seal. Now, it used to be necessary for deeds to be signed with such a seal attached to them, but we did away with that some years ago. Now all you have to do is to say this contract is executed as a deed, and it's dealt with by the law as if it's a deed. So it's a lot simpler these days. Now the next point about types of contract is to think about standard forms of contract, because they're extremely important in the construction industry. Standard forms of contract are also known as standard form contracts. It's the same thing. Although we refer to standard form contracts, there are actually hundreds, literally hundreds, of standard forms in existence. Standard forms are often drafted by committees that represent different interests in the industry. One of the problems we've got is that the construction industry is not a single, coherent or homogeneous industry. It consists of a number of different industries, which is a point that's often lost in many things that we read. So when I say it consists of many different industries, think of the civil engineering industry, the building industry, the petrochemical industry, nuclear power. Each of these is a different industry. They all form part of the construction sector. The construction sector is an economic concept. But the idea of an industry is that it consists of a coherent bunch of buyers and suppliers, techniques, technologies, and so forth. The civil engineering industry tends to involve a completely different bunch of people to the building industry, apart from some contractors who occupy both spaces. The petrochemical involves another different set of actors, and the nuclear power industry, yet again, another different set of actors. By actors, I mean specific clients, specific suppliers, particular kinds of materials, techniques, technologies, and so forth. So each of these different construction industries have their own standard form contracts, and again, they don't just have one standard form contract. Every construction industry has dozens, if not hundreds, of standard form contracts. Then, of course, you've got to think that within each of those construction industries, there are repairs and maintenance. There's new construction, there are leases, there are warranties and insurances. So these are different kinds of relationship, and they exist in all of the different construction industries. Again, each with its own distinct and exclusive groups of participant. So there's some interesting aspects of law that arise in relation to standard form contracts, which we will deal with in a future episode. For now, it's just enough to know that we will have to look at different kinds of standard form if we're going to understand building contracts in the round. So to summarise what we've covered in this episode, contracts do not need to be in writing, they could be verbal. Simple contracts are known as contracts underhand. Deeds are known as contracts under seal, and standard forms of contract are widely used. And of course, one additional final point is that standard forms of contract are frequently not used as standard forms. the people who use them tend to amend them to suit their own particular individual purposes. But as I say, we'll deal with those issues around standard form contracts in a later episode. For now, that's all I wanted to cover today. So thanks very much for watching. See you next time. Bye.